Good afternoon, fellow managers of this beautiful organization. Thank you so much for discussing with us today the labor laws. And these are important for you to know specifically, just to be able to discuss to employees as they come up to you and ask. General knowledge of these laws is important anyway, so just when you see any injustices occur or violations, that way you're able to go ahead and speak to them. My name is Erica Ramirez-Trujillo, and again, as most of you should know, if I have not personally come up to you and introduced myself, I am the HR manager of this organization. We're going to dive right into the most common labor laws that we'll be discussing today, which is the Civil Rights Act of 1964, Employee Rights ADA laws, Department of Labor laws, Family and Medical Leave Act by the United States Department of Labor, Safety and Health Standards, the Affordable Care Act, and options to replace it, pay equity, and then also the Employee Retirement Income Security Act, Fair Labor Standards Act, Worker Readjustment and Retraining Notification Act, and the National Labor Relations Act. And we're going to go ahead and dive right in. So these are some of the broad and specific acts and laws we will cover in this presentation, and how you as a manager are expected to interpret these laws and explain them to employees so that no labor laws are violated. We're going to go ahead and go right into the Civil Rights Act of 1964. So this act, signed into law by President Lyndon Johnson on July 2nd, 1964, prohibits discrimination in public places, provided for the integration of schools and other public facilities, and made employment discrimination illegal. So your specific expectation as a manager during the hiring and any employment process is to only judge people based on their skills and how they perform the job duties, and never to judge them by skin color, race, gender, color, and or religion. And always be on the lookout again for anyone who is violating this. So again, this law was passed in 1964 and to end all segregation in public places, and just letting everyone know that we don't accept any tolerance of any injustice of this kind. Going on to the next bullet point would be employee rights. So the employee rights was specifically refers to ADA laws, and that all employees have the right not to be discriminated against if they have disability. Individuals with disabilities are protected from employment discrimination by Title I of the American with Disabilities Act and the Rehabilitation Act of 1973. So for the two laws that protect Americans with disabilities, again, that's the ADA law and the Rehabilitation Act, based on the U.S. Equal Employment Opportunity Commission. Title I Act excludes any employer or labor union from discriminating against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and other terms, conditions, and privileges of employment as per the United States Equal Employment Opportunity Commission. A person with a disability is someone who has a mental or physical disability, an impairment that hinders them from being able to perform everyday activities. Even if they're an employee now and do not seem like they have the impairment, and if it's still regarded or written on their profile or in any past notes that they have it, they are always protected by ADA laws. The employer is one who will have to make a reasonable accommodation for the employee and should not be looked over for a position based on their impairment when they can do the job details, as long as they have the assistance that they can by the manager. A way to help accommodate a workplace for an employee would be to alter facilities for an employee, such as maybe building a ramp for an employee to use instead of stairs if they have a wheelchair, or adjusting the employee's work schedule so that they can have time to get to work based on their impairment. Also, new equipment should be ordered or old equipment should be adjusted, so if the employee needs, they can use the new equipment to complete their job and the duties assigned. And all employers not allowed to fire someone if they need tools to complete a job and the employer has not provided or accommodated the tools for the employee to use properly. And then again, reasonable accommodations should be made by the employer if there's maybe like a test for the person, just so that way they have the same chance as the next person. ADA laws also require employees to provide a qualified person to read an employee, just in case maybe they're blind or need an interpreter if they are deaf. Maybe. The next act, which is the Rehabilitation Act of 1973, prohibits discrimination from federal assistance programs, federal employment, and or in the employment practices of federal contractors based on a disability, based on the website Earn. Basically, as a manager, don't count someone out just because they have disability. If they have, again, the qualifications to do the job and just need reasonable accommodation, then you as the manager need to accommodate for them. And we're going to go ahead and go on and move to the next act, which would be the Family Medical Leave Act of 1993. So you are entitled as an employee, a full-time employee, to 12 weeks of unpaid job protected leave per year. It also requires that your group health benefits be maintained during your leave. So as a manager, before granting the leave, ask yourself if the employee leave qualifies based on the reasons stated that on their paperwork and the type of employee they are. So they would not qualify if they are part-time. Again, even though their pay is paused, their benefits are not. So this act applies to all public organizations and companies with more than 50 employees to offset the temporary loss of one employee. According to the Department of Labor, the employees, if needed, need to be within 75 miles of the work site. This act applies to any employee. The reasons that would qualify an employee for the leave would be the birth of a new child, complications within the pregnancy, adoption, or foster care placement, or to care for an immediate family member who is gravely ill, or if the employee personally cannot work because they have a serious impact to their health, and or assisting a family member who is sick due to coming back from the military. We're going to go ahead and go on to the next one, which should be the safety and health standards, which is, oh, I'm so sorry about that. Again, health and safety laws. An organization by the name of OSHA, which is Occupational Safety and Health Administration, is in charge of making sure employers keep their employees safe. Because of OSHA, worker deaths in America are down on average from about 38 worker deaths a day in 1970 to 13 a day in 2020. Worker injuries and illnesses are down from 10.9 incidents per 100 workers in 1972 to 2.7 per 100 in 2020. This means that there should be no obvious workplace hazards and all proper protective equipment should be issued by managers. That is your expectation. Also, for the health of all employees, even yourselves, managers should confer about when it will be done. But a test of the organization, like fence, for example, it should be done once a year. Good thing OSHA is there to keep employees safe. However, as a manager, we don't want to give them a reason to have to come around. We want to notice the hazards before they occur, so that way the employees don't say band together if they notice that they're constantly getting sick and hire their own inspector, for example, and the inspector finds mold in the vents, which could have been prevented if you as the manager kept all inspections up to date around the facility. We don't want any lawsuits to occur, so if you keep everything up to date, then there's no worries as to why the employees would ever need to go outside of the company. And if they ever come up to you with any health and safety hazards, please make a note of it and double check as to what they're specifically referring to. We're going to go ahead and go on to the Affordable Care Act, again nicknamed the Obamacare, since it was signed into law by President Obama. It is put into place so that it's a law that was put into place. So if somebody, an employee, say, for example, can't afford a medical or health care plan, there's no options for them based on tax credits. This is based on your poverty level. So as your expectation for a manager, you should know the health care plans we provide. You don't need to know the exact details specifically, but you do need to know where to find it and what we do provide and how to look for it. And also, if they can't afford what is on there, then you can also suggest to them that the Affordable Care Act could be a good second option. Again, as a manager, you're not allowed to specifically pick for them or tell them which one you prefer. You're just only to read with them about the healthcare plans so that they can decide on their own what is best for them. We're going to go ahead and go on to pay equity. And again, I'm so sorry I'm going through all this fast. I know that we only have a couple hours within our day to work through everything. So that way you can go ahead and get on back to your employees and helping them. Thank you so much again for meeting with me during your time. We're going to go ahead and go on to, again, the pay equity. So the California Equal Pay Act is the main law under this category and was signed into law in 2015. So if you notice a pay difference, and the employees coming up to you about the pay difference, say between a male and a female, look at the role difference that the male versus female is doing and compare and contrast before immediately siding with the party and saying, oh yeah, you're getting paid a lot more versus this person. So that way we can double check the compare and contrast, like I was saying. Look at the employee's record, how long they've been working there, and also the similarity between the work that they do. So we want to go ahead and explain that sometimes, yes, it does happen. The differences between pay, maybe because the female and male do have the same education, but maybe the male decides to apply for a job that doesn't the female requires the female applies for a job that maybe doesn't require a college degree, and the male does at the same time of employment, but the male is getting paid more because he is doing a job that does require a college degree, but maybe the female isn't. So we want to go ahead and look at what are the similarities between the jobs, and if they are exactly generally similar, then we'll go ahead and see where the change is. We're going to go ahead and go on to the Fair Labor Standards Act. So, Fair Labor Standards Act establishes minimum wage, overtime pay, record keeping, and youth employment standards affecting employees in the private sector and in federal, state, and local governments. So, as a manager, you are expected to know what the minimum wage is for our organization, be able to tell employees where to find the labor laws posters stating it, and also on their checks if they do receive any overtime, or also on the labor laws on the HR section of our website. It does say specifically what overtime pay will be if they do go over. Again, we do not want them to go over, but if it happens, we want to make sure that they are definitely accommodated for their time. So we want to make sure year by year that we are updated as to what the minimum wage is and if it's changed by law. And we want to make sure that everyone that's hired is getting the paid for the number of hours that they are on the clock and here at the company organization. So again, anytime the employee is doing work for the organization, they should be paid accordingly. This act also protects child labor and the fact that minors have a maximum number of hours they can work, while also going to school to prevent the organizations from keeping them too long and too late. Okay, and then we're going to go ahead and go on to the ERISA, which is Employee Retirement Income Security Act of 1974, protecting retirement savings from mismanagement and abuse, and clarifies that those in charge of those savings be held to a higher standard. So you want to explain, as a manager, explain all benefits such as retirement and welfare benefit plans to the workers and or their beneficiaries so there's no miscommunication. So specifically, we want to be able to know what the benefit plans are, where to find them. Again, you don't need to know them word for word, but where are they on our website to explain to employees? And then also, if the beneficiaries do call, how would you help them? So it's your job to be able to understand the benefits and be able to explain them to somebody who is looking to retire in the near future, or again, speaking to the family looking for closure after the loss of a loved one, if maybe they are still covered under these benefits. And then we're going to go ahead and go on to WARN, which is sorry, I didn't mean to click the wrong one. I'm going to go ahead and go on to Worker Adjustment and Retraining Notification Act. This requires companies with 100 or more employees to notify affected workers 60 days prior to closures and layoffs. Your expectation as a manager is to make sure you know the script. What are you going to say to them before you speak with them? We want to make sure that we are all saying the same thing to each employee so that we don't get ourselves into a lawsuit if employees ask specific questions. We want to make sure that we know what to say. The last thing we would need, again, would be a lawsuit for saying something wrong when we are already losing money, hence a layoff or closure. So we don't want to specifically tell in detail of everything. We want to stick to our script. Again, it's a protection for employees so that they can find work after a closure or layoff notice and not have to worry about where their next paycheck is, because hopefully during the 60 days, they had time to find a job to replace the one that they're losing. And then last but not least, we're going to go ahead and go on to the National Labor Relations Act. So this last labor law act that you as managers must know, this grants the employees the opportunity to unionize without retaliation for the organization they work for. Under this, employees are allowed to collectively come together and bargain with the employer about what benefits or rights or wages they would like, and then they can all come together to a uniform agreement and again, not get retaliated against. This is also called the Wagner Act by the main author, Senator Robert Wagner. And then thank you so much again for listening to everything that was going on today. So basically, what is next for the company? Have weekly check-ins with your employees. meet with your team. Make sure you have maybe a suggestion box so that way they know that they can come to you if they have any questions in case somebody's maybe a little bit shy. Brush up on your labor laws so that way you're able to explain to all employees. And thank you so much for listening. I hope you have a great rest of your day and